Joseph Schwerha and Drazen Dragicevic. If not, here are copies of the report. You have copies of the report, if not, pick them up. They're nice, they have an envelope, they're shiny. No pictures, but still. Okay, so we had this discussion for quite a while. We also had a discussion at the last Octopus conference, and we have this this paper covering Netherlands, USA, and Croatia. And in this study, you also find in the beginning a reference to the case law of the European Court of Human Rights. There is a study also by the Court of Human Rights. Somewhere in this research paper, you find a link to that one. And one of the cases listed there is Kayuu versus Finland. Are you aware of this case? You all aware of it? Yes, here? No?
No, not really.
Okay. The short version is that there was quite some time ago, about 10 years ago, there was a 12-year-old boy in Finland, and somebody had posted his details on some sort of platform on the internet, on some sort of a forum, where he offered his sexual services. So apparently picture and contact details and so on, and of course it was not done by him, but somebody had posted his details there, and so the parents went to the police, and the police asked the service provider to take down Are you okay? Can you hear? Okay. The service provider was asked to take down this particular information, which was done. But then the parents wanted to know who did it. And the service provider said, sorry, under the law, we are not allowed to give out this data. They went to court. The courts also said, it's unfortunate, but under the law, the provider is not allowed to give out this data. They went through all the instances in Finland, and eventually this ended up at the Court of Human Rights. And in December 2008, the Court of Human Rights ruled that Finland failed to protect the rights or the dignity of this 12-year-old boy by not having laws in place that allow such an investigation. And in the meantime, the laws had been changed, but still it was too late for the boy. So the government of Finland had to pay some sort of a fine in that connection. What is interesting here is that the court said there's a positive obligation by states to protect citizens or people against crime. They made a specific reference to the Budapest Convention. They also made a specific reference to the law enforcement ISP cooperation guidelines that we had adopted 7-8 months earlier at the Octopus conference in April 2008. As we said, we are discussing here in particular Article 15, which is broad, which says that Articles 16 to 21, the procedural powers of the Convention, are subject to conditions and safeguards provided for under domestic law, which shall provide for the adequate protection of human rights and liberties, and there it makes then a reference to the European Convention on Human Rights, but also to United Nations covenants on human rights. because the convention also applies to non-member states of the Council of Europe, states that are not parties to the European Convention on Human Rights, and for them then also United Nations treaties would apply. They are fairly broad. They refer specifically to procedural powers. I know Douwe will have some comments on this particular point. You can extract, when you look at how to implement, how to provide guidance in Article 15, you would have certain expectations of what a state should have in place when it comes to rule of law requirements, meaning general principles: there should be no punishment without a law, everybody has the right to a fair trial, interference in rights should always be only in accordance with the law and necessary in the public interest. Investigative measures are to be prescribed by law. Anybody whose rights are violated should have the right to an effective remedy, etc. So these are general rule of law requirements. And then when you look more specifically into Article 15 and how this applies with regard to the procedural powers of the Convention, you can deduct the principle of proportionality, which is actually specifically mentioned there, judicial or other independent supervision, grounds justifying the application of the power or procedure, and the limitation and the scope or the duration of the procedure, of the measure. And the powers and procedures must be reasonable and consider the impact on the rights and responsibilities of third parties. So in a way you can operationalize to some extent Article 15. Is this us or is this, are we disturbed or others disturbed? Can you hear me? Okay, so it's other people that had the white noise. And for us, it means that when we look at whether a country implements Article 15, we have to see whether a country is actually parties to international human rights treaties, assess how the above requirements are reflected in the constitution of a state, but analyze also how the requirements are reflected in the criminal law of a state in general, and more specifically how it applies to Articles 16 to 21. And this is what you find in the studies done on Croatia, Netherlands, and US. You have the example there. So, with that, with these introductory remarks, how shall we start? In which order shall we do that? Sophie, we start with Sophie, who is actually the Secretary of the Data Protection Committee of the Council of Europe, the TBD, and who is also guiding the modernization of Convention 108 on data protection.
Yes, thank you. Thank you. Is it working? Yes, you're hearing me. Good morning, everybody. Yes, as Alexander mentioned it in his introduction, I am going to focus on Article 15, more particularly data protection, right to privacy. So indeed, the key words in this article, it's that the domestic law has to provide for the adequate protection of human rights and liberties, and as Alexander stated it, there is a express reference to the European Convention on Human Rights. The article which here I would like to develop more is the Article 8 of the European Convention on Human Rights, which is the article which safeguards the right to respect for private and family life. The first paragraph of this article grants the right, everyone has the right to respect for his private and family life, and then you have a paragraph 2 in this article which provides limitations for this right, and I will read it because it's very relevant for law enforcement and cybercrime. There shall be no interference by a public authority with the exercise of this right, except such as in accordance with the law, that's the first condition, it has to be prescribed by law, and is necessary in a democratic society in the interests. And then there are a series of interests which are listed, one being national security, public safety, and also prevention of disorder or crime. There is no precise and exhaustive definition of this right, which is safeguarded by Article 8, which is the right to private life. It's a notion that has been evolving with the case law of the court. But what has been stated very clearly and repeatedly by the court is that the protection of personal data is one of the elements of this right to private life. The court had many times that the mere storage of information about an individual's private life is an interference with the applicant's right for private life. So this is very important. It's the link between this Article 8 on right to private life and personal data protection. So now I will come more specifically to the Convention 108. Alexander, you mentioned before that the Budapest Convention passed the test of time. It's even more relevant for the Convention 108 because it's 31 years old this year. It was drafted so over 3 decades ago with no reference to any technology at the time and granting very general principles, which means that today it's still fully relevant, fully applicable. We have countries around the world which have an interest in the convention because as the Budapest Convention, it is a convention which is open to non-member states of the Council of Europe and precisely because it's setting minimum principles of protection in the field of data protection, it could be really accepted by most of the countries in the world which already have a data protection legislation at the moment. One point I would like to make is about the title of this convention. It's the Convention on the Protection of Individuals with regard to the processing of their data. It's not about data protection. I want to make this very, it's the German influence of Datenschutz, data protection. Here, for the Council of Europe, when the convention was drafted, it was about protecting the individuals. It's a human right. It's not about the protection of data as such. I often hear data protection is security. No, it's much more than that for the Council of Europe. So one key article for you of this convention is the Article 3 of the convention, which states that the convention applies horizontally public sector and private sector. So law enforcement authorities are bound by the provisions of this convention. The principle laid down in the convention are, as I said, very basic principles of data protection, fair and lawful collection of the data of the processing. The data should be stored for specified legitimate purposes. It shouldn't be used for ends incompatible with those purposes. It should not be kept for longer than is necessary. That's also a very important point. Another principle which is set by the convention is the quality of the data. The data which is collected and which is processed must be adequate, it must be relevant, it must not be excessive. This idea of proportionality in the data that is collected and how it will be processed. Then another very important right which is granted by the convention is that the persons whose data is processed, which we call the data subject, have a right of information. They also have a right of access and rectification to their data. In addition to those basic principles, the convention also highlights a specific category of data, which is called sensitive data. And for this type of data, and there is a list in the convention, the principle is that there shouldn't be any processing of this data except if there are complementary safeguards which are provided for by the law. And there it's also important for you because in this list of sensitive data is mentioned criminal records. So I've been just giving you basically the main principles, how the convention is protecting them. But as I was mentioning in respect of the Article 8 of the European Convention on Human Rights, that there is a paragraph 2 to this article which provides for a possibility to limit, to restrict the exercise of the right. We have the same thing in the Convention 108. It's the Article 9 on exceptions and restrictions, which has exactly the same logic and the same basis, which is that when it's necessary in a democratic society for a limited number of grounds, there can be some restrictions to the exercise of that right. There, I link it, I think, Professor, you will go back to the case law of the court in more detail, but I think I'm not going to detail the cases. I just want to come back to this notion that I mentioned before, which is the interference would be allowed when it's provided for by law and necessary in a democratic society. Provided for by law, it means that, is it working? There needs to be an element of control to avoid the arbitrary action of the state. So this law has to be accessible. The person who is likely to be affected by the rule should have access to it. And it should be foreseeable, certain. It means it should be sufficiently clear to allow the individuals to regulate their own behavior. The court has developed an abundant doctrine on proportionality. It's really a case-by-case test, whether they assess in a particular circumstance and situation if there was a need, a pressing social need, to have a restriction to the right. So this, as I said, applies to the Article 8 on the right to private life, and we have exactly the same notion and the same limitation in the Convention about processing of personal data. The Convention sets the general framework, but the Council of Europe has been also developing sectorial texts, which are non-binding texts, its recommendations, on several topics. And we have a recommendation which regulates the use of personal data in the police sector. It's a key recommendation. It dates back from '87, but it has been integrated in the Schengen acquis. So it's become, by this way, a binding provisions, and it's still nowadays a very, very strong reference in the field. I will not go through the recommendation, but it basically translates the principles I've been mentioning to you: right of access, proportionality, quality of data. All this is translated in details for the law enforcement, and how the law enforcement in processing the data should respect the right to data protection. Another recent sectorial text, which is also of interest for you, is a text on profiling. When we hear about profiling, instantly we think about behavioral advertisement or targeting, but there again, this recommendation, like the Convention 108, applies both to the public sector and the private sector, which means that profiling performed by public authorities, migration services for instance, is also covered by this recommendation. Let me now make a link between this convention, Council of Europe Convention. It gathers at the moment 44 countries which are party to it. We are hoping that our first non-European country to become party will be Uruguay. It's pending, and it should be the case early next year. And as I said, this is the basis for a general global framework, but we have to articulate this framework with other regional frameworks, and in Europe, specifically with the framework of the European Union in the field. And as some of you may know, the European Union has, at the beginning of the year, proposed two new drafts which would regulate the matter, a regulation and a directive. A draft directive precisely tackling the question of prosecution of criminal offences, prevention, investigation and detection of crimes. There is one point I would just like to raise to your attention of this draft directive, which is an article establishing the link between the data protection regime that the European Union will be putting into place and international agreements, whether bilateral or multilateral, that the member states of the European Union have taken in the field. And this article, which is the Article 60 of the draft directive, basically invites the member states of the European Union to amend, where necessary, within 5 years after entry into force of the directive, international agreements that they have concluded. And this will have an impact on our discussions later and the Budapest Convention. So now let me come to a very concrete illustration of data protection, law enforcement needs and requirements, and I link it to internet governance and to the ICANN questions. For those of you who follow, the registrar's accreditation agreement in ICANN are currently being reviewed, and the law enforcement sector has basically supported two requests. Is that the databases in which all data of the registrars and persons registering domains, that this database, which is called the WHOIS database, be first annually checked. The data which is in this database should be annually checked. That was the first request. The second request was that there be a retention of the data 2 years after the contract with for the domain has expired. And so those two requests was made by law enforcement for obvious reasons. But there, data protection issues arise, and the Article 29 Working Party, which is the group of the 27 data protection authorities in Europe, has been sending a letter to ICANN about that, saying that if the grounds and the motives are admissible, what is proposed is not lawful. That's in particular the retention for 2 years of the data, and the Working Party 29 underlined that if that's what ICANN wanted to do, for Europe at least, they would need to have a legal basis for that. And concerning the annual verification of the contact details in this WHOIS database, there also they objected to it, because if the accuracy of the data is one of the principles which is key, there may be other ways than the WHOIS database, which is a public database, which is an incentive for basically false information to be given to this database. And the Working Party of the Article 29, for instance, proposed that an alternative layered access model to the database be put in place to make sure that those who register their data then provide accurate data. This is basically one of the concrete illustrations I wanted to make in the field of internet governance and the balance between law enforcement interests and the right to data protection. This position that I mentioned from the Article 29 Working Party has been supported by the Consultative Committee of the Convention 108. So there, as I said, it's 44 countries. It's not the only 27 EU member states. So thank you very much. If you have any question, I'm available anytime. Thank you.
Thank you, Sophie. Douwe has an immediate comment.
Just a footnote, actually, which I think is quite important. As I said, one of the big civil liberties issues is the fact that in fighting crime and terrorism, there you have private sector data, law enforcement data, and national security data. The EU has no competences whatsoever in the field of national security, so it can't deal very well with slippage of data from law enforcement agencies to national security agencies, but Convention 108 does apply also to national security agencies. Just a footnote there. Thank
you. We have to come back to that also later in the discussion when it's one of the problematic areas, this unclear boundary between national security arena and the criminal justice arena that causes many headaches. Professor. Sorry. Okay.
Hello, you hear me? Okay, thank you. My name is Murat Güneştaş from Turkish National Police. My question is just for Sophie, because you mentioned about the WHOIS databases and the records that shouldn't be taken, for example, even the data protection agencies don't agree about 2 years. Historical data, I think, we are talking about. There are some companies selling this data forever. Like, for example, they're storing the data since, I think, 1995, and they are selling this data, this historical data. You're making a search, and they tell you, we can give you a report, some historical report about this website, for example, who owned this website, for example, over 15 years. So what do you think about this? I mean, they have this knowledge, they stored this information, and they are selling this to law enforcement, even to anyone. What do you think of it?
Yes, thank you. I mentioned that one of the principles which was important was purpose limitation. When you collect data, you collect it for a specific purpose. You shouldn't collect more than what is necessary for that purpose. That's one thing. Then you shouldn't use it for something different than what it was collected for. And you should keep the data as long as is necessary for that purpose. That's basically the European system. It's the system in most of the countries that have adopted the data protection legislation. So in that case, if the data was collected for something else and then is used and reused for different purposes than what it was collected for, obviously that's illegal. So then it's a matter of enforcement. Which law applies to those firms? Are there any data protection authorities in charge of enforcing? That's not clear, but we can discuss it further if you want.
Many questions there. I stopped working for United Nations in 1995. When I go to Vienna to a particular hotel, I still get a United Nations discount because I'm still registered in their database as United Nations. So sometimes it works, but it's... But anyway, there are serious issues there we have to address, also in connection with the who is issue. Zahid is also a strong party in that discussion.
I'll just use this, thanks. I'm a counselor on the GNSO with ICANN, and this is something that's debated a lot. Who is an issue which is hotly debated, even now, especially with the law enforcement recommendations, etc. A couple of just clarifications. There are different types of who is data, different levels. There's a thin who is data, which is very, very limited information. There's a thick data, which depending on the registry that you are or registrar that you're actually registering your domain name with, they may have a thick who is policy. Then there's the issue of what is private, what is public, because not all the data related to a domain name is made public. For instance, phone numbers and certain contact details will not be made public. But then there's also the issue that, or the availability to anybody who registers of the use of something called a proxy. So if you don't want your information to be made visible, you can actually utilize them. And in fact, what I've noticed is that registrars are selling that as a default service. So the moment you register it, you automatically, you have to actually uncheck it to say, I don't want to buy this service. That way your data will not be sort of disclosed to the public at all. But if you have not taken the proxy service and your data was made publicly available at least to the thin or thick level, then once it's out there, then it's out there. That's the problem. So I think it's a question also of awareness for those people who are registering, that when you're providing this data, it is going to be public. Those notifications to registrants needs to be much more clearer. I agree. Some users may not understand that. So I think those are the kind of issues that maybe that arise from that. Thank you.
And with that, all the law enforcement challenges. Assuming we are here in Azerbaijan, I'm running a malicious website here, and I use a proxy in the US. That means law enforcement here in Azerbaijan investigating this website would go through mutual legal assistance in the US just to find out who is behind this website. So a lot of issues. Helps protect privacy, but also is a major issue for law enforcement. So one would have to find a workable solution there. Professor, sorry.
Thank you.
It's getting too exciting here.
I refer to something that I heard from Mr. Dewey. I think you said that one of the major problems with the Cybercrime Convention is bad drafting. Yes. Well, I must admit that I disagree. I think that's not a matter of bad drafting, but rather a result of some wide range of compromise so that more countries accept that treaty as an international instrument, first binding instrument that help us fight against cybercrime. The major question is how to protect human rights regarding that instrument and implementation of the Section 2. Well, in that light, I see two keywords, if I may say so. First, flexibility, and second, balance. Flexibility we can achieve by implementation of all of the procedural measures that are provided by the Convention, even more than that, if anybody wants. But this is the minimum standard that we must all implement. This standard allows us to have a flexible system that will enable law enforcement agencies to choose between different provisions and to choose the provisions that are less intrusive for suspects, offenders, and after all for the third parties. At the same time, we need the system that will balance between competing rights. On this graph, maybe is better shown. All the provisions we can grade it. Depends on the level of intrusion. From the simple provision in Article 16, explicit preservation of computer data, that is the least intrusive, to the interception of content data that we can all agree is most intrusive, most demanding, and most effective to all that whose data is intercepted. So I think that the main point is to choose the provision, to choose the instrument that is least intrusive by which we can achieve the goal. If we don't have a choice, if we don't have a flexibility in our legal system, especially procedural legal system, then we don't really have a choice. So it's no wonder that just about 20% of countries that implemented cybercrime conventions have fully implemented these criminal procedure provisions. I think their main mistakes is to try to modify existing provisions on search and seizure, interception, or better say before eavesdropping or tapping conversations and so on. What's more interesting is that simple provisions, such as simple instruments, such as explicit preservation of computer stored data, it seems that it's harder to implement than such provision as search and seizure, which refers to the intangible things, to the computer data. I don't know why. I think that, after all, search and seizure is very, very intrusive and very demanding provision that can affect human rights in great manner, even a lot more than first three of these provisions: production order, explicit preservation and partial disclosure of traffic data, and of course the least intrusive measure, explicit preservation of stored computer data. So, on one hand, we must achieve that flexibility, implementation of large, not large, but a number of different instruments that will allow law enforcement agencies to efficiently detect, prosecute, investigate, and prosecute such a party is the priority. If they have such an instrument, of course, they can choose the one, and in fact, we can oblige them to choose the one that is least intrusive and that will help them achieve the same goal. On the other hand, I already said that what we need is balancing. Balancing is maybe the crucial problem when we talk about this. It's very hard to find a balance between the needs of the law enforcement agencies, the instrument that they will use, and on the other hand, preservation of human rights. Balancing is very hard to achieve and very hard to find the unique answer to that question. It's simple because there are all kinds of reasons, from historical, legal, political, and a number of other reasons that doesn't allow us to get the simple answer and what safeguards and conditions to implement. After all, we see that's the reason why only such a small percent of countries fully implement these provisions from the Section 2. How to achieve balance? If we stick to the convention, then we can see that there are different requirements that convention offers. First, mandatory, then some that are recommended in the convention and the explanatory report. And what I would like to especially stress, good practice. Good practice, then we can learn from the others' experience, and I think that this conference is one of the important examples of that good practice that will help us solve some problems, see how other countries, other member states implemented this in their legislation, what are their experience in practice, and what are the problems for the protection of the human rights. Mandatory recommended, well, that's the crucial thing. Here, and the crucial question that we can hardly find the right answer. First, there's no doubt that this article 15 is the most important article in the whole section. To many, that's the most important article in the whole convention, because it can be referred to the whole convention, not just to these procedural provisions. Unfortunately, it's very abstract. Abstract because of the reason I already said: history, differences of political opinions, legal systems, and so on and so on. This balance is to be achieved through the implementation, the highest standards in the field of protecting human rights. I think that's the minimum, and that's the main framework when implementing these provisions and the safeguards and conditions about them in our legislation. On the other side, of course, Ms. already mentioned principle of proportionality, one of the main principles that we must all obey. In most of the countries, after all, it is a constitutional category, so it applies not just on cases that refers to the implementation of the Cybercrime Convention, but also to any other case. Second, some recommendations about the conditions and safeguards are strongly recommended by the Convention, and some are recommended by the explanatory report, such as judicial or other independent supervision. Although Article 15 and the explanatory report mentions just the judicial external control and supervision, I think we can take a broader point to that. So in some cases, especially when it's case of more privacy intrusive measures such as interception of content data or real-time collection of traffic data, even more types of scrutiny or supervision can be combined. For example, parliamentary, professional, and especially civil scrutiny. So if you have just the judicial scrutiny, that doesn't mean that the other types of supervision can be combined together. We had recently bad experience, so it's obviously that just one type of supervision in the sensitive cases just isn't enough. I think that they can be, in such a serious cases, combined with other types of supervision. Grounds justify the application, so as a precondition to use and implement such procedural instruments, limitation of scope, time limitation, and so on. That's all contained in the Article 15 already of the Convention, so it's very concrete. It's on us to decide on which of those provisions it shall be implemented as conditions and the safeguards. Also, in relation to some provisions such as interception of content data, Article 21, there is also recommended that some other conditions and safeguards are implemented, and there are some general principles, general legal principles that should be implemented, such as right against self-incrimination, legal privileges and specificities of individuals such as lawyers, and so on and so on. Explanatory report also suggests that parties were implementing measures, especially these two very severe privacy intrusive measures, implement a number of other safeguards and conditions, and that's in fact that framework that the Convention and the report give to us. So it's not so, after all, abstract as many says. We have a number of different conditions and safeguards that are provided by the Convention and recommended by the explanatory report. We can combine them, we can choose. What's most important, we must implement a flexible system. Flexible system that will allow law enforcement agencies to choose between different procedural instruments and to in each moment choose the one that is less intrusive for everybody and the aim is achieved. I stress once again the importance of the supervision. Supervision, not just judicial, but also parliamentary, professional, as well as civilian. Supervision, of course, if we have bodies that are competent, that consist of lawyers and IT specialists, IT experts. In that way, we have solved 5 or 6 years ago the problems with our intelligence services after we implement that different kind of scrutiny, different kind of supervision of their activities and their intrusions in privacy and other human rights.
Thank you. There's one point I wanted to underline here, and that relates also to the data protection issue. The Budapest Convention talks about specific investigation and specific data, and it does not contain a general data retention obligation like in the EU directive on data retention. So it talks a lot about specificity, which is also in itself providing safeguards. Douwe.
Yes, if I can comment on a few. I wasn't criticizing actually so much the text of the drafting as the process and the fact that so much of it at the early stage was in secret. But it's an important general point. I think the more that international law is going to impinge on individual freedoms, the more necessary it will be to conduct as much as possible of the negotiations in a wider context than has happened with the Cybercrime Convention, but that is 10 years ago, or 8 years ago, and with ACTA. So that's a general point. You made a very good point, Professor, about there always being a correlation between the more intrusive a measure is, the more safeguards and the higher level of authority you need. I think you will find that reflected in most legal systems. There is a problem with the kind of data that we're talking about here, in particular communications data, that it is very difficult to... Some data that are generally regarded as traffic data, as metadata, can be very intrusive. In particular, I'm talking about location data. And I think location data is highly, if you just think of where you are at a particular time. The Naomi Campbell case. You remember a photograph was taken of the model Naomi Campbell coming out of an Alcoholics Anonymous building. That is specifically about location. So some of the data that are treated as relatively intrusive in the Cybercrime Convention, I think actually can be very intrusive, and especially if you use it in certain combinations. When I look at the 3 country reports that have been very kindly reproduced, I see a lot of weaknesses in every system. When I look at the Dutch system, one thing that you may not all be aware of, but I happen to be a Dutch lawyer, although it's a long time ago I was there, is that an assistant prosecutor is actually a police officer. All police officers in the Netherlands are formally given the honor of being an assistant prosecutor. So that is not much of a safeguard when you say you have to have the authority. It has to be confirmed by a prosecutor, but that is still very low. The report on Croatia has this one instance when apparently on the authority of any policeman, enormous amount of information can be asked of internet and e-communication service providers. I think the safeguards that we're talking about are very often not adequate given the level of intrusion that's involved. I am particularly critical, and I hope nobody's going to of the United States. I think in a way that is the big elephant in this room. Everybody mentions cloud computing. in practice, cloud computing very often means servers in the United States, because that's where some of the main providers of cloud services are based. The American system on access to personal information by law enforcement agencies and by national security agencies from a European point of view is appalling. I really do not believe that it meets anything like what we Europeans would require. The report as produced here skids over a number of those things, and unless you are aware of the weaknesses in the American system, you can't read it in the report. It's there if you know it, but you don't see it if you don't know it. In particular, pen and trap warrants, as they're called. Pen trap warrants is an old system that related originally to telephone operating machines when they still operated with cables. As the author of the report himself says, there is no judicial scrutiny of a pen trap warrant. There is no judicial scrutiny at all. It is a rubber stamp. You have to go to a judge to get the warrant, but there is no judicial scrutiny of the basis for the warrant. All that has to happen is for a prosecutor to say, I believe this is relevant to an ongoing investigation, and he must be given the warrant. On top of that, there is a doctrine in the United States called the third-party doctrine, which means that the moment you hand over data to any private entity, Facebook, Twitter, car rental companies, airlines, whatever, you lose your expectation of privacy and you effectively are no longer protected under the Fourth Amendment. That is a massive breach of what the Europeans would consider as minimal data protection requirements. And finally, there is a very bad tendency in the United States to extend US constitutional protections only to US citizens. In Europe, we have the fundamental approach in the European Convention of Human Rights that says everybody has these rights. So American citizens have the rights under the Council of Europe Convention and under the ECHR. That is not the same on the other side of the Atlantic. So data, once they leave any of our jurisdictions and end up in the cloud, and in particular on American servers, I feel are totally unprotected. Now, I then noticed this particular article in the Cybercrime Convention that says that when foreign authorities ask for data from a particular country, the country can make the passing on of the data conditional on, for instance, it may only be used for this particular investigation. What I would like to hear from the people here is that used? Do you sometimes, do you often, do you always make a condition of the provision of information that it will only be used for a particular inquiry? And what, in that case, is the response from the United States? I can't believe that the United States can honestly comply with that condition. And if the United States makes clear to you that it can't comply with that condition, what is your response to that in turn? So there are really, really big problems, I believe, in particular in relation to the United States, but also at the domestic level, where I don't think the safeguards that have slowly built up over many years in the criminal procedure codes with regard to searches of houses, searches of private properties, offices and all that sort of stuff, is all reasonably well regulated. I'm not saying perfectly, but reasonably well regulated. But transposing that to the internet environment is not done rigorously enough. I don't think that there is sufficient awareness of the level of intrusiveness of the data that we're talking about here. And I think you need much stronger safeguards, and hopefully the Cybercrime Committee will be able to make some recommendations, and maybe even coming out of this meeting. Rather than saying, yes, there are different levels, I think we need some indication of what kind of level for what kind of data. Subscriber data, relatively simple. Traffic data, well, if it is only the header, perhaps not so much. The moment you add location data, I think you're getting very intrusive. That's almost as intrusive as content data, sometimes more intrusive. Those are just some points for consideration.
No. It's nothing wrong that you say or a different opinion, but maybe I forget to say previously, there are traditional measures in procedural law, such as search and seizure, but when implementing and modifying them to the virtual world, then the other conditions and safeguards must be implemented. One of them, because in this case, a police officer must act very fast, expeditiously. One of the ways to enable them to do so is the subsequent convalidation of the orders that issue, for example, court. Such a subsequent court convalidation may be very useful. It's an efficient safeguard, but at the same time, efficiency of the law police agencies is achieved. Oh, just.
Okay, it's a pity we don't have any FBI agents and U.S. prosecutors with us. In discussions we've had with U.S. prosecutors, they would say that you're completely exaggerating, that the conditions they have to meet to get access to data are much higher than you would have in most European countries. And actually, they are appalled when they look at the systems of European countries. So, okay, but it's not a...
There is a difference between whether they seek access to data on U.S. citizens or to non-U.S. citizens.
They argue that is only the case. Sorry, if it's access to data under national security letters or FISA and so on, not in the criminal justice area where they said there's equal protection. That's how they argued also in public. One can hold them accountable for that. 3-4 weeks ago, when there was the discussion in the EU Parliament in Brussels on the data protection package, because there were specific questions raised to that, and the only exceptions there was FISA, which says it shall not apply to U.S. citizens.
Have a look on this. Have a look on this chart in your own report on page 43, and look at the second column. On page 43. The second column makes very clear that any data held by a non-public provider is totally free. Yes, 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 yes. There is no restriction there at all.
Yeah, but it says voluntary disclosure.
Well, that's the point. That is exactly the dishonesty of the American lawyers when they try and decide. They regard voluntary disclosure. Anytime I give information to my telephone, if I make a telephone call, I voluntarily disclose to my mobile network operator all the details that he records. And then you have the third-party doctrine, which means because I have voluntarily given it to the telephone operators, I have lost my expectation of privacy. They can give it to the police. If you talk to human rights lawyers in the United States, they will tell you data are totally open, can be handed over to law enforcement authorities on an extremely weak basis. And the second point is this pen trap warrant, where again in the text itself it says, very strange text. I have to look at my own printed out thing. It is an interesting contradiction in the text itself. On page 51, I think it might be, if it's 51 here as well. Yes. You can see the sentence. There really is no independent investigation by the court into the truth of the statement made in the application. So if a prosecutor says, I want a pen trap warrant, he will get it. Page 51. Oh, the second paragraph where it says pen trap statute. Pen trap statutes provide virtually no protection whatsoever. And the interesting thing, it says, this is acknowledged here. There is really no independent investigation by the court. And then strangely, the next sentence says, Thus, judicial oversight is a constant safeguard. There is no oversight, no judicial oversight over pen trap warrants. They must rubber stamp them on the application of a police officer. And it's that kind of, what I really find dishonest. At the very least, we can ask the Americans to be clear and honest about the weaknesses in their system. And otherwise, you can't have a very good debate. The further thing about, there was a very interesting case in the American Supreme Court, Jones, in January this year, about a GPS device being fixed to a car that somebody was using. And it was held to be a violation of the Fourth Amendment, but only because it was a physical violation of the property of the car. The reasoning of the dissenting judge is the interesting one. Justice Sotomayor, who is always on the liberal side of the Supreme Court, she says exactly what Europeans would say. I would not assume that all information voluntarily disclosed to some member of the public for a limited purpose is, for that reason alone, disentitled to Fourth Amendment protection. That's what we would say. But she is in the dissenting minority, and she's always an outrider. She's much more liberal than the rest of the court. Fourth Amendment protection is very, very limited indeed, and the Americans must stop pretending that it isn't. Sorry. It's a pity to shout at the Americans, so there's nobody in the room.
Hi. I think it's true that we don't have the U.S. presence in the room, so it's a bit challenging. But my understanding, looking at the rest of the world, and this is a very U.S. versus Europe debate, from what I can understand, it's fairly Eurocentric. The issues we're discussing, because if you look at the rest of the world, there may be concerns that they have where they don't actually want to comply with a lot of the privacy principles that exist in Europe. Now, I'm not saying that those principles are not right or that they shouldn't be, they don't assist users, but there are certain views that other countries have, such as the U.S., such as many countries in the developing world. You could mention a whole bunch of countries on the eastern side, which may be developed as well, who may not go to the extent that the European Union or privacy protections extend to. And that is the reason, I believe, that we have this deadlock also on an international treaty on privacy and data protection. So that's not an issue that a cybercrime treaty can resolve. It's a separate matter related to data protection and privacy, and I think you have a convention in the Council of Europe on that, and that's a challenge, etc., that's ongoing. So I think we can't fix everything in the world. That's one aspect. Second, we also need to, let's be fair, at least the U.S. has certain provisions. If you come to Russia, China, developing countries, Arab states, they have nothing. In fact, many discussions you'll have with law enforcement in those countries, they'll tell you, we don't even want to have a legislation at all. And the reason is, well, why don't you want to have one? Because we don't need enablement to be able to do these things, because the moment you bring in a law to enable, then the question begins as to what the restrictions should be. So there's if you look at the world map, there's a completely separate sort of an extreme side to that. So I'm not saying that addresses maybe some of the concerns that you've raised, but what we need to sort of look at it in good measure as a balance. With respect to my understanding, I'm not a U.S. attorney, that foreigners are not subjected to U.S. constitutional protections. I understand that, absolutely. But the FISA statute, from my reading of it, actually has a judge, someone called a FISA judge, who issues warrants. Now, you can criticize him for being liberal in the way he grants those warrants. That's fair. I can't say. I've never looked at how he decides them. But I remember the issue of when, in the Bush administration, warrants were being, or wiretaps were taking place under FISA without the judge's authority, and it became a pretty scandalous issue. It came up in the press. And the judge actually sort of, I think he resigned, I'm not sure, but some sort of an event took place. So it does sort of speak to some sort of oversight. Whether that's practically effective or not is a different matter. I can't judge that. But there is judicial oversight in FISA, I understand, from what I've understood. And with respect to voluntary disclosure of data, that is a different culture. Let me sort of, because we've had to deal with this issue in our country, trying to decide, do we want to adopt EU principles on data protection, or do we want to adopt what may be called the US or other principles on data protection? And I can tell you there's a problem. And let me tell you the problem that developing countries have with EU principles. If we were to comply with the EU principles or look at them, then we would not be able to access outsourcing of data from other countries, because there's a very strong protection on data protection in the EU. The directive says you can't transfer data at all. So that we lose a market. So it's really an economic issue for many developing countries trying to adopt those measures. So it's a different culture where they say, well, if you voluntarily gave up your information to Facebook, you have an option. Don't do it. But once you've given it up, it's out there. If the Facebook policy says that they cannot disclose it to somebody else, and they do, then they can be sued for breach of contract. So there's that provision available under U.S. law. But it's a different culture. So I think we need to sort of balance out. There are different views in different countries. And I'm sorry I'm rambling a bit, but I think we need to sort of balance it out. It's not just a EU proposed data protection approach that can apply to everybody in the world.
Thanks. I'm also a bit confused, and maybe we should take this up indeed with U.S. prosecutors. I mean, you refer to FISA, which has its own procedure because it's related to intelligence and national security matters. But the counterparts we have been dealing with from the US say that it would be illegal by a service provider to voluntarily disclose content in the US. It's different for subscriber and traffic data. There's a different level. That's why also US headquartered multinational providers can give to European law enforcement subscriber data and traffic data in a rather direct manner and so on. But in the US, they say they cannot give content data, and they say in the US it would also be illegal for them to disclose content data. So I'm a bit surprised that it should be so easy to get just by.
I think it's 1881A, section 1881A. But I mean, maybe we're getting into too much technical, and I am not a great expert on this. I think it's section 1881A of FISA, and I'm just trying to look it up here. Casper Bowden has written quite extensively on this, and I think he has better legal detail, which I'll gladly try and get for you and send to you. But there is a serious problem, and our colleague from Pakistan does point out there is a big cultural difference. But from the European perspective, we say data protection, including purpose limitation, and data quality and things like that, are part of the ECHR system, part of the constitutional requirements in Europe, that we cannot easily abandon and say we can cooperate with countries where data, very sensitive data, are sent without adequate safeguard.
Yeah, just to complement on that, I think that this distinction between various regions of the world, it's really EU. It's not Council of Europe, it's not the convention I was mentioning, because if you take, for instance, the US Bill of Rights that was proposed by the Obama administration, it basically corresponds to the principles I mentioned before. So it's true, the EU framework, and you mentioned it, for instance, for transborder data flows, is very strict. The requirements are very strict. But there are also, I mean, for transborder data flows, yes, the rule is no data transferred outside, except if you're adequate. But then there are also some flexible tools you can use. But clearly, I just want to underline, it's not the Council of Europe text there. There is a difference, so when we speak Europe, there it's EU framework.
And the question would also be, under the EU framework, whether any data accessed under FISA would apply, because FISA is, again, national security, and national security is specifically outside of the scope of this future, the current also, no? The current and the future EU data protection package. It's different for Convention 108, but
one of the things we will discuss here this afternoon, I think, is exactly this blurring of the lines between criminal prosecution and national security in relation to terrorism, but organized crime, and organized crime is of course linked to terrorism. That whole context is really complicated, and you can't leave the national security provisions out of it, I don't think.
okay, there are other human rights also, including food. Now, there's a problem. The right to food has not been fully implemented in this building. Now, we were looking for solutions. We were looking, including a solution to find a bus to take us somewhere to get food, but even that seems to be a problem. Now, there is an option. Actually, it's maybe the only one. That we have there is coffee somewhere, however, and sugar and sugar.
Maybe there is a food.
No, the food is gone. The food is gone. They had food, but apparently it's gone. It's about it's in this building. It's about a 5 minutes walk. Gerko knows the way. Now, an option is that we have like a half-hour coffee break to pick up a coffee over there, come back and we finish earlier. Is that okay with everybody? Pick up some sugar things.
We have to write something here. Giga.
No, you don't have to pretend to be Giganet this time. Okay, but Gerko knows the way.
Okay, so it's outside. We have to go outside and go to that part of the building, almost to the airport. Yeah, and we can enter that place with these badges. But also, I think it's better to bring the passport or something because there is also a check-in.
Okay, but we follow Gerko.